Hello everyone, this is Aishwarya KOLKAR and I'm here to explain you about essential and types of contract. So let's see the content. First one is meaning of contract, second is essential of contract and third is types of contract. So let's begin with the meaning of contract. Contract is nothing but an agreement made between two or more parties which is enforceable by law. We can define contract as an agreement enforceable by law. Contract can be understood with a formula. Contract is equal to agreement plus enforceability at law. Now let us understand the essential element of a valid contract. First one is offer and acceptance. It is one of the essential of a valid contract. There must be an offer and acceptance of the same. Second one is legal relationship. The parties to an agreement must create legal relationship. Agreement of a social or a domestic nature do not create legal relation and such cannot give rise to a contract. Third one is lawful consideration. Consideration is something in return. Consideration has been defined as the price paid by one party for the promise of the other. Fourth one is capacity of the parties. It means that the parties to an agreement must create competence to contract. A contract by a person of unsound mind is void. Thus, a contract entered into a minor or by a lunatic is a void. Fifth one is free consent. For a valid contract, it is necessary that consent of the parties to the contract must be free. Sixth one is lawful objective. It is also necessary that agreement should be made for a lawful objective. Every agreement of which the object or consideration is unlawful is illegal and therefore void. Seventh one is writing and registration. According to Contract Act, a contract may be oral or in writing. Although in practice it is always in the interest of the parties that the contract should be made in writing so that it may be convenient to prove in the court. Eighth one is certainty. For a valid contract, the terms and conditions of an agreement must be clear and certain. Ninth one is possibility of performance. If the act is legal and physically impossible to perform, the agreement cannot be enforceable at law. Tenth one is not expressly declared void. An agreement must not be one of those which have expressly declared to be void by the act. Now let us understand types of contract. Contract is classified on the basis of three divisions. First one is validation, second one is formation, and third one is for performance. Now let us understand one by one what they are. On the basis of enforceability, there are three types on the basis of enforceability. First one is valid contract. The contract which are enforceable in the court of law are called as valid contract. Second one is voidable contract. If one party to the contract has the option of enforcing a contract by law but not at the option of the others, it is a voidable contract. Third one is void contract. An agreement may be enforceable at the time when it was entered into, but later on, due to certain reasons, for example, impossibility or illegality of the contract, it may become void and unenforceable. There are two types of contract in void contract. illegal contract, and unenforceable contract. Second type of contract is on the basis of mode of creation or formation. First one is express contract, where the offer or acceptance of any promise is made in words. The promise is said to be expressed. For example, A has offered to sell his house and B has given acceptance. It is express contract. Second one is implied contract. An implied contract is one which is inferred from the act of the parties or course of dealing between them. Sitting in a bus can be taken as an example to implied contract between passenger and the owner of the bus. Third one is quasi contract. In case of quasi contract, there will be no offer and acceptance. So, actually there will be no contractual relationship between the partners. Such a contract which is created by virtue of law is called quasi contract. Last type of contract is on the basis of extent of execution. First one is executed contract. In a contract where both the parties have performed their obligations. Second one is unilateral contract. In a contract, one person has performed his obligation and the other person is yet to perform his obligation. Bilateral contract. It is a contract where both the parties are yet to perform their obligation. Bilateral and executory are the same and interchangeable. Thank you.